Well, hello and thank you for joining us. Welcome to the number 5 inaugural webinar seminar. What we are hoping to do is talk about how criminal trials have progressed in the advent of COVID. My name is Michelle Heeley and I am the Deputy Head of the Criminal Group, and I'm joined today by Simon Hunka, who's one of our senior juniors within crime. So Simon, thank you very much for joining me.
No problem.
Simon, I think you've been fortunate in that you've carried out 4 effective trials now.
Yes, just finished my 4th one today.
And have they all been prosecution, defence, or a mixture?
All of them defence, actually. The reason I've been so lucky is actually because most of my practice is in Warwick, and it's mostly a defence practice there. And Warwick was the first court in the Midland Circuit to start doing trials, so I've been quite lucky, really.
I've done 1 from each side, so I've done 1 prosecution and 1 defence, both in Birmingham. So I think it would be helpful to talk about the procedures that are in place pre-trial, the differences between the court centres, how they could maybe change, and then also then the trial process itself. So in terms of the pre-trial stage, what I've found is that there's a lot more preparation that goes into ensuring that the parties are trial ready. Is that something that you've noticed as well, Simon?
Yes, I'm sure it's the same in Birmingham, but what they said to us is they'd like all the paperwork to be ready, I think it's 72 hours before a trial starts, so that they are literally in situ, untouched by human hand before the jury arrives, so jury bundles sitting there. Is that the same in Birmingham?
It is. What that's meant for me being prosecuting is that I've had to ensure I provide a jury bundle at least 1 week in advance to the CPS, because they need to have the procedures in place to print it out, leave it so it is becomes COVID-free, and then it's transported to the court building and has to sit, as you say, for at least 72 hours. What we've found is that you therefore, ordinarily at court on day 1, there would be perhaps discussion between counsel as to what is to go in or come out of a jury bundle, and sometimes that can involve legal arguments. So in some cases, it's led to extra folders being prepared with alternative A for if the legal argument succeeds, B if it doesn't, C if it's a mixture. And I've had to have a lot more involvement with defence counsel far sooner in advance of the trial than I think I ordinarily would have done.
Good example of that kind of thing, actually. There was an application, a hearsay application that started one of the trials that I've done recently. Prosecution were trying to rely upon the evidence of a particular witness, and a count hinged upon the evidence of that witness. And so it was either going to be a 1 or 2 count case, and instead of having the normal count 1 and on the first page and maybe count 2, a little bit of it at the bottom of the first page and going over, counsel had put the footer that you would normally see on an indictment underneath the first count, and then quite separate page with count 2 and the same footer below. Not the kind of thing that would have caused a problem if we had to use those 2 pages, but it just meant that it was just ready with whichever situation arose.
What I've heard from other courts, they're adopting a different procedure. So I think it's Leicester, for example, their protocol has been that any document that is to be handed to the jury must be encased in the plastic pockets.
Document wallet.
Yeah. Now, I think in a short trial or a non-document heavy case, should be quite straightforward. But I've got a case coming up at the moment, which is going to have about 300 pages for the jury bundle. If you add in the physical space that those pockets take up, it's just not practical. I personally think there should be a nationwide protocol as to how each court should deal with jury bundles. And I think the 72 hours protocol seems to be the most effective at the moment.
Yeah, I would agree with that. But actually, every one of the trials I've done, there have been things that have been handed to the jury. For example, each and every case has had written directions at the end, and they, of course, can't be done prior to the trial. So what's happened is, once they've been sorted out, they've been printed off, and the usher has taken, as long as the usher's wearing gloves, it's been deemed to be safe enough in the circumstances. But there's an additional thing that the ushers have had to do that ordinarily anything that's handed out, that was handed out in court, because of the layout of the jury, which I'm sure we'll get to in minutes, or the layout of the court, the ushers can't move around so freely because, of course, they'll be going quite close to various members of the court and too close. And so what they're having to do is anything that has to be handed out needs to be done in breaks. And so when the jury are out of the room, put on their respective desks. And so when they come back, they're organising their papers themselves.
That's interesting. I've heard of other courts where they're using litter pickers to hand out some documents and also exhibits, which I think if you have rubber gloves, that surely would be a better way of dealing it.
Yeah.
What's been the process with jury bundles for the witnesses?
We haven't had that. I've not been involved in the kind of cases where you'd have to take witnesses to many documents in a jury bundle. However, we did have that in the trial I've just finished. And I didn't know how many of the witnesses I'd be wanting to take to the jury bundle, but the first one, he definitely needed to. We simply asked that she wore gloves to do that. And so that once she'd done that and just left the jury bundle where it was.
Yeah.
I mean, I suppose you could print off spare jury bundles, but there comes a point where you've got to make a decision, I suppose. But something that's happened certainly is the realization that you've actually got to print quite a lot more material. You don't just do the normal 12 copies or whatever. It's 18, I think we found, because all of the jurors have to be on their own with their own copies of things.
And that is something to be aware of, actually, that the juries have to have an individual bundle. So you've got to watch the jury. One of the advantages normally of having 2 jurors per bundle is that if one of the 2 is struggling, the other one can assist and make sure they're on the right page. So I think you've got to take a longer time to make sure that they are all following you and are all on the same page as well. That's another practical thing to be aware of.
And that's not easy because the layout of, I don't know what it's been like at Birmingham, but in Leamington and Coventry, which are the 2 places that I've done trials in, they're very different, but the general theme is the same. You have to use all the available space, and that means quite a lot of looking around, and it actually can be panoramic. In Coventry, I had jurors behind me where I was sitting, which was pretty unusual.
Gosh,
and to the extent, actually, I had to angle my computer because there was a juror quite literally a step to the side and a step back sitting behind me throughout the entire trial.
Well, we'll come to the layout shortly, but that's interesting. But in terms of pre-trial preparation, I think cooperation, getting the details of your opponent at least 2 weeks in advance, it has to be the way forward.
Yes.
Now, when it came to the actual trial process, what Birmingham are only able to use 2 courts, and now the 2 large corner courts. The layout in Birmingham is that the jury are spread throughout the room, so in counsel's row where counsel would ordinarily be sitting, and thereafter the counsel are in where the press box would normally be. So you can see, as you say, you've got to be very, very careful about looking at computers because your screen will be on display. So that's something, again, I think that you have to be quite conscious of.
Yeah. What I found, firstly, in Leamington, it's not been that much of a problem. Anyone that's familiar with the 2 main or the 2 larger courts at Leamington will know it's very much counsel on one side and jury on the other. That's still the same. They've just split the sides because there's more room, in fact, where counsel ordinarily sit, room for the press, solicitors and probation officers. And so because there's more room on that side, they've in fact used pretty much every inch to fit the entire jury on that side of the room. So there's no such problem. But in Coventry, it really, really was difficult, actually. Not so difficult when I was asking questions because I would tend to hold my computer or whatever I was having right in front of my chest and no one could see anything. But I had to be quite mindful of it every other time.
Yeah. And then how the trial actually progressed. So there wasn't room to have ordinarily the jury panel to be selected. Normally 15 people would be brought into court and from that 12 chosen. What they did was they had 3 panels of 6 brought up at a time. So if you had any questions or any names that to be read out, that had to be repeated 3 times for each separate panel of 6. Now, the one case that I was involved in, we had, I think it was over 40 different names. I think a better way of doing it would be that we'd have been allowed to print those names, give that list to the 18 downstairs, rather than having to read out that same process over and over again, because swearing in the jury took over an hour and a half.
I don't, obviously each court will have to deal with whatever courtroom size they have. At Leamington, and in fact also in Coventry Crown Court 1 is relatively small compared to all of the courts we've been talking about, both Birmingham and Warwick. But what they did there was the same as at Warwick, which is in fact the entire panel come in, so 16 of them. They each have a designated spot, quite literally, with a sticker on the floor, so a 14 on the floor, and the 14th panel member goes and stands on that. They then have everything done in one go. So we didn't actually have the 3 sets of 6 or whatever it was. It was literally everyone in at the same time. Once they got selected, they then would affirm using the screen. Mm-hmm. But instead of them moving to their seats, what would happen is that every single one would be asked to leave the room again in reverse order And then there was essentially a door through which those that weren't selected would be siphoned off. So when they come back in, they then take their seat. So it takes a little bit longer, but it was quite effective, actually.
That does sound effective. The problem we had in Birmingham was to say that it was 6 at a time. Then all 18 would be taken down to the waiting area, which was another courtroom. The court clerk then had to phone down and put on speakerphone those that were selected. And that got repeated back and forth 3 times to ensure that the right name had been called out. And then the 12 that were selected were then brought up, given their number, and they entered one at a time. And it was a very, very cumbersome process. I think the way that you have talked about it in Coventry and Warwick, that sounds a bit simpler and actually far more efficient.
I went, because I was the second trial. I was part in the second trial there. The first 3 they had, His Honour Judge Lockhart had invited all of the counsel that were to be involved in those first 3 to come for a bit of a walkthrough of the entire process. And I think it was anticipated that actually the swearing in would take, I can't remember exactly how long, but 3 times or 4 times as long as it actually has taken. It's been really quite effective, actually. A little bit longer than normal, but not too much longer. Something
to note, I think, is that jurors are told now that generally they will affirm. If they wish to swear on the Bible, then they're told they have to, or any other holy book, they have to bring their own holy book with them. Yes. My experience has been that almost all have simply affirmed. And I wonder if this could be the end of the oath as we know it.
Well yeah, if it's worked during the pandemic, then it probably should work thereafter. It's probably a fair point.
One of the things often takes time in the swearing in process. If it's a particularly sensitive holy book, the person taking has to take the book, unwrap it from its cover, check it's the right one, and then take the oath. So it's interesting how quickly they have done away with that process and just moved on to affirmation.
Yeah, absolutely.
One important aspect to consider is the lack of facilities that there are at court. So that means for counsel, we weren't provided with any form of water bottles, refreshments, so anything that you want has to be brought to court with you.
Right. Well, at Leamington and Coventry, they did actually. So it's like ticking their box, perhaps. But well, at least on day one, I think you had to refill it, but they'd give you a water bottle. Also, hand sanitizer on the desk. They've done it really quite well. Yeah. Yeah.
Hand sanitizer everywhere, and they've used that to actually disinfect the jury bundle. So between witnesses, the usher has gone with gloves on and wiped down the cover of the jury bundle. So that's been quite useful. But the lack of facilities has meant that whereas ordinarily during a trial, we would have maybe a break mid-morning, sometimes a break in the afternoon, that simply hasn't happened. And I think because of that, once the trial has got going, it's become far swifter.
Yeah, I think that there was an anticipation that if anyone wanted a break, it would take too long to have one. And so I can understand perhaps in Birmingham, again, it's going to differ from building to building. It depends quite how far everyone has to go. I've just finished a trial in Coventry where I think by far the most comfortable place for the jury to be was in court, in fact. And so I don't think they minded at all pressing on and continuing. We got through the trial quite quickly. But to be honest, that's been the experience in Leamington as well. All of the trials, not only the ones I've done, but speaking to others involved, I don't think anyone's spoken of any significant delay. Not really.
No, I think trials are going faster because of the level of preparation that's going into them. And also because the courts are only able to have the trial work in them. If you say it's a 10:30 start, there's no other work that's holding it up. So it is a 10:30 start. There's no other detritus in court, and you just are moving straight on with the process with few interruptions.
The only difficulty that I've had is that even though, of course, there are fewer cases and fewer defendants coming to court in other cases in the building, because of the restrictions in the cells, because quite a lot of the cases that are finding their way to trial are involving people in custody for good reason. Because of the restrictions in the cells, they can't use all of the rooms available, only those that are big enough. I did find on a couple of occasions, actually, that I either couldn't get to see my client or I had to wait and we were a little bit delayed because of that. So that is something. But to be honest, the court buildings haven't been that busy with other work with people in attendance to cause a huge problem, but it's something of note.
Yeah. I think in Birmingham, if you haven't been able to get to the cells, they've been able to provide a designated telephone so you can have a phone conference with your client. But even then, they've sometimes had limited capacity. So the case I was in, the trial was due to start at 10:30. but the first conference that was available for counsel was at 10:45. So
Right.
that, I think, needs to be a factor that's built into the length of trial factors.
Yeah.
Looking at practical considerations, in Birmingham, they can't use any screens at the moment. So if you've got a vulnerable witness, whereas ordinarily they may have screens, now they have to use the video link.
Yes, that's certainly the case at Coventry. I think it's the case, memory serves me, in Warwick as well. Although Warwick, it's slightly different because the two main courts there don't actually have physical screens. There's simply a different area in court. And I think actually, because of where those places are located, they're not far enough away from the various, be it council or whoever else. So I think they've done the same there. But certainly in Coventry, there was a witness that ordinarily would have been behind a screen this week, but was over the link. And we just have to deal with it. It does show how flexible the court process is actually, that lots of different problems have arisen. And we've just been able to roll with this in the main.
Yeah.
With everyone working together, it's pretty clear.
One problem that has arisen with screens is that the case I was involved in had juniors. Because of the size of the courtroom, there wasn't enough room for the juniors to be in court with the leaders. Therefore, they were following the case, as were the family of the deceased and family of the defendant on the CVP. They were linking up to a different court.
Right.
And that meant that if you were then using the link, so the link to the witness, they could hear what was being said, but they couldn't see the witness. Or if you put something up on ClickShare, then they couldn't see what was going on in the courtroom because there was only so many avenues of technology that were available to be used at any one time.
Yeah, that's I think a problem that Coventry is facing. I think Coventry is opening up for grade 1 work as of 2 weeks' time. At the moment, they're doing other cases, but in Leamington, there isn't actually a link to another court as such. They have access still in the public galleries because in those two courts in Leamington, it's a completely separate area up above. Yeah. However, only 1 or 2 people can go in there at a time. But I don't think they're experiencing quite the same problem there.
Yeah. I found it difficult not having the junior in court because I don't think you appreciate how often you will turn around to ask an opinion or just check a document. That all had to be done via email communication, and you had to be quite careful to make sure you weren't sharing anything on ClickShare at the same time as sending emails to juniors. So that is something that does need careful consideration for people going forward, I think.
Yeah, absolutely.
Other than that, I want to look at perhaps ways that it could be improved or how we move forward, because Birmingham's a 16-court centre. At the moment, they're only dealing with 2 trials. Now, I understand that a number of courts are going to be fitted with Perspex screens, so effectively the jury are shielded within their own Perspex bubble. At the moment, they haven't got a timescale for that. We're told it's coming in weeks, but with no date.
No. On the face of it, that would be the game changer, because being in any of these courtrooms, they look like almost like you're in an IKEA with lots of markings on the floor to go various places, and it's so apparent that the problem is the distancing. If they can, well, not eliminate that, but reduce that by the introduction of Perspex screens, it's going to make a huge difference. I still think some courts are going to struggle because, for example, at Coventry, the idea of a Perspex screen, the jurors are so close together there, but I don't know exactly how they have it planned, but hopefully it will help.
What I don't see is a way forward using social distancing for multi-handed trials. Have you got many multi-handers that have had to be put back because of the pandemic?
Lots. I haven't been involved in anything other than a single-handed case for trial. I know, having been in another case before His Honour Judge Lockhart, who is essentially managing things, obviously, at Warwick, he said that, I don't know if it started yet, but certainly the plan was soon to have 2-handed trials. I don't know if it could be extended to 3. Any more than that, certainly any case in my diary involving multiple defendants is just being adjourned. There's nothing that can be done about it at the moment. But that's particularly concerning, of course, particularly if they're in custody.
Yes. To my mind, we should be using different venues. I think lecture theatres should be being utilised for multi-handeds where they're on bail. But as you say, the real issue is the serious cases, either serious multi-handed drug dealing, firearms, murders, where you have a number of defendants all in custody, and they have to therefore be in a secure environment, which can only be an established court building.
Yeah.
I don't see how that can be established. unless we move to perhaps better protective equipment, be that people who are not actively talking at the time wearing masks, more use of gloves, things like that nature.
Yeah, although that I can imagine being quite uncomfortable over time. I know, not the trial I've just done, but the one before, it was when masks were essentially just being introduced and people were a little bit uncertain as to when they need to wear them. And certainly at both Leamington and Coventry, people are wearing masks in a public area, the concourses. But when we had the jury selection process, when they all came in, I'd say half of the jurors, jury panel, were wearing masks. But by the time they'd gone out again and came back through, they'd taken them all off. So I very much got the impression, actually, that jurors were uncomfortable wearing masks for any prolonged period of time. And whether that's the way forward, and I don't quite know. I had a strange experience where in one of the trials, in fact, the only person in the whole room wearing a face mask was the witness who was giving evidence at the time. So there were lots of people not wearing anything, looking at someone, and I thought it was going to be a problem. In fact, it wasn't, because as long as you can see the eyes of the witness, we learned it wasn't so much of an issue.
That is interesting. I'm surprised, because I personally find it very difficult to read people when their mouth is covered. I don't think I appreciated how much I relied on that to gauge people's emotions. So it's interesting that the witness gave their evidence in that way.
I've got to say, I thought this is never going to work, but actually it really was fine. I think you got a true sense of the witness, and I wasn't expecting that, but there we are. It's the only instance I've had. Every other witness has not worn a mask. Yeah.
Are there any other aspects that you think could be improved or have worked particularly well?
I actually, it's going back to the printing. I think what's likely to happen is, even though, of course, there are some benefits to getting all of the work done prior to trial, the front loading of it, the reality is, you and I know, once the trial starts, things happen and things need to be changed as you go along. Agreed facts are created, and I think what is happening is, as soon as the court staff get used to the process and they're diligent in wearing gloves at all times, actually that's speeding things along. So sometimes I'm finding that the emphasis, as helpful as it can be, the emphasis on getting everything so front loaded can cause certain difficulties, because you're then reluctant to change things when they need to be changed.
Yeah.
But a little bit of relaxation around that, actually, going forward, in my view, might help.
Yeah, I found the court staff were very, very cautious. I think they've been on the front line of this for so long, and they have seen outbreaks in other courts, that they are now reluctant to touch or handle anything at all if they can avoid it. Whereas, I say, with perhaps better protective equipment being made available to them, they might feel more comfortable, and that in itself, as they would speed up the whole process.
Yeah, maybe.
I think the real issue is that the lack of resources that have been thrown at the system for so long now, and the backlog is just building with no end in sight to finishing that.
Have you noticed there's another difference that those of us that have been at Leamington certainly have noticed, that they must have done, I'm guessing, 15 or so trials, maybe more now, and quite a large number of those compared to before have resulted in hung juries. And that was something that I don't think anyone expected. And it causes people to think, doesn't it? But I wonder whether the distancing between individuals has been something of a cause of that, because it's a bit of pop psychology, I suppose. Having the opportunity of getting to know your fellow jurors might make you a little bit more receptive. And the interesting point was, at the trial I've just done this week, in fact, in the trial judge's address to the jurors when they were sworn in at the start, was actually a direction to encourage them to get to know each other. I've never heard that before, but it may well be that there's some discussion behind the scenes that is something that is of concern, that the jurors are essentially like little islands moving around the court.
That is interesting, because physically they are not in the proximity that they used to be. And when they go out to discuss their verdict, whereas previously they would be in a relatively small room, all around one table, able to look each other in the eye. Now, I know in Birmingham, they're using another courtroom to deliberate in, so they're still physically distant from each other. And as you say, they may not have that collegiate atmosphere or camaraderie that has built up in the course of other trials.
And so actually going into the time estimates for cases, it's a bit anecdotal at the moment, I'm sure, but I think the courts are actually expecting cases to be a little bit longer in terms of the jury's retirement, rather than the earlier stage, the actual trial.
That's something that's worth noting. And of course, if it's a retrial, that is adding yet further to the backlog of cases to be heard, isn't it?
Yeah, well, one of the trials, as you said at the start, I've done 4. In fact, the second of those was a retrial of one of the counts in order to get the case finished, essentially. One of the counts in the first trial was hung, and the trial judge wanted to have that case dealt with sooner rather than later. And I don't think that's the only one where that's happened.
Well, that's interesting, because usually if it's a retrial, it will just go off for another 2, 3, 4 months whenever the court can hear it again. Well, thank you very much for joining me. I hope that anyone listening to this has found it useful. It's been our own personal experiences of what we found that has worked, the challenges that there are, and hopefully as more trials are up and running, people will be able to add into their comments. Feel free to contact the crime group. We are crime@no5.com. If you have any queries, anything that we can answer, then please do get in contact. But I hope you've enjoyed this. My thanks to Simone for taking the time out to join me today. And we look forward to any feedback that you may have on this webinar. So thank you very much indeed.
Thanks, Michelle.